to unlist a matter, a contempt case, number 5 of 2025. And one is contempt case 12 of 2025.
For listing,
For listing of
mentioning for
26.
listing,
Yes.
you have to mention before the senior bench.
Single.
Lordship, I would like to mention item number 10.
Item,
10.
what do you want?
With consent of both parties, matter may be taken up after 3 weeks. Lordship. 10. 1.
Mr.
Yes, Your Honor.
You are for the petitioner,
For the petitioner.
land counsel for the petitioner, with the consent of the land counsel for the other side. Praise for listing this matter. Praise for adjournment to be listed after 3 weeks. 3 weeks.
Yes. Lordship.
Item 3.
10. 1. 10.
Okay. The prayer is allowed. This is matter after 3 weeks.
Lordship, interim order is there.
Para, the interim order passed earlier shall continue till the next date. Okay.
Highly obliged.
Yes. 3 and 4.
This matter may be listed after a week.
After
A week.
week. 3 and 4.
3 and 4. In 3, I am the respondent, and in 4, I am the petitioner. I've taken the consent of the other side.
Okay. Mr.
R.L. Thungan.
R.
R.L. Thungan.
Thungan, your name? Okay, your name is there.
Yes.
Okay, in 4 you are for the petitioner.
Yes. In 3, I am for the respondent.
Okay, Mr. R. Thungan, land counsel for the respondent in CRP 2021 and petitioner in CRP 42/2022 with the consent of the land counsel for the other side. Praise for adjournment of the matter to be listed after
A week.
a week. The prayer is allowed. List this matter after a week.
Much of it.
Your Lordship, I like to mention item number 14.
1-4.
Yes. This matter has already been disposed in Judicial Magistrate, Chief Judicial Magistrate, SEPA, Your Honor. So this matter stands in fractures. So I would like to withdraw this
Okay.
matter.
Mr.
K. Tana.
Land counsel for the petitioner submits that the matter under challenge has already been disposed of by the trial court.
Yes.
Therefore, this matter has become in fractures. And thus the matter has become in fractures, and therefore you want to withdraw the petition. Stop. The prayer is allowed. This petition CRP stands dismissed on being withdrawn. Withdrawn, okay?
Idea.
On withdrawal, huh? Okay.
May I please, ma'am?
Yes.
Marlon matter, this matter is pertaining to the Marlon, the non-completion of the execution process by the ADC Dapuri. Here in this case, my lord, as my lord know, nowadays the execution power has been entrusted to the Deputy Commissioner and the Assistant Commissioner by the amendments of the Arunachal Pradesh Civil Code Acts 2023. Therefore, my lord, out of the Kebang decision dated 18th and 2019, the execution was filed before the ADC matter. And accordingly, that everything was going on smoothly, that both the parties were heard, and thereafter the ADC has passed the order directing the respondent respondent to deposit the amount which has been decided in the Kebang. Thereafter, other party has not appeared. So what is left is only by issuing the warrant of arrest to the respondent to compelling him to deposit the amount. That part of the execution was remained. But despite of that, now the ADC is refusing that to the level that he had passed the order and he has no authority. He is denied to issue the warrant of arrest. So this is only the.
Where is the denial
matter.
order?
Uh,
Where is the denial order?
My lord, this denial, no denial order is there.
See the last order, page 27.
My lord, page 20.
It is under process only it appears. Now on failure to appear in person on the scheduled date, warrant of arrest shall be issued. This is the order, last order.
Exactly, my lord, this is the last.
Then
Thereafter, my lord, this, now the,
that was in way back in, no, not long back. It was in the March, last March. Then what do you want? You make an application. You make further application.
my lord. Thereafter, my lord, now, plainly refused.
Application for attachment, arrest or whatsoever.
Exactly, my lord, that
As per execution.
I am appearing before the, my lord, this concerned authority, ADC.
Have you made application?
My
Not
lord,
yet, not yet.
no
Now
application.
now you have to apprise that since that was failed and that was, and it's been long since last order passed and see they are not complying with the order and direction, then you make an application, one small application,
My lord.
miss case for attachment, arrest or sale of the property.
Exactly, my lord. But
You may benefit.
despite of that, my lord, what I have been, my lord, denied that since order has passed and if the person is not ready to deposit, then the concern is,
No, you see,
concerned authority is
from time
not
to time
ready
you
to
have-
take update.
from time to time, if the executing authority is not doing anything or not proceeding, you have to make application for appropriate application for appropriate action against the
My lord.
judgment letter. Okay, you make an application. This is otherwise you want this order, last order to be quashed or set aside.
No, my,
So that otherwise that direction cannot. You make an appropriate application
my lord, I got it.
and withdraw it with the liberty.
With liberty to,
With liberty, because this is not mature enough at the moment, because he has not yet refused. It is under process only. On the process, unless you challenge or unless he refused, it's very difficult. There's no way at all.
exactly, my lord. My lord, one difficulty is that he has refused verbally that if you
No,
want,
verbally, you make an application.
my lord,
Let him refuse in order. Then you come.
I got my lord, I got it. So, my lord, with liberty.
Okay, Mr. C. Modi, Land Council for the petitioner. Praise for allowing him to withdraw this petition with liberty to file FS if so advised. The prayer is allowed. This petition is dismissed on being withdrawn with liberty as prayed for. Okay,
Oh,
make appropriate application. Under 21 CPC. No? Who is for the petitioner? Who was for the petitioner? It was listed yesterday, it appears. After some time. Probably because of the traffic.
Yes,
Today, in fact, there was a heavy traffic.
Okay.
We'll wait for some time, okay?
I'm seeking for adjournment. I'm for the respondent. The key thing,
You are for the
respondent.
You earlier made an application for filing affidavit. You have not yet filed. File affidavit.
Yes, sir, okay.
You are Mr.
Sita jo.
appearing on behalf of.
Tea time.
Tea time.
Respondent.
Appearing on behalf of the respondent number. Sole respondent. Or how many respondents are there? How many respondents? You are for respondent number? All the respondents. They are.
Yes, yes, sir.
Okay, appearing on behalf of all the respondents, prays for further 2 weeks' time to file affidavit in opposition. The prayer is allowed. List this matter after 2 weeks.
Your obliged.
Your Lordship, this matter may be passed over for a moment because
Here also you have not yet filed affidavit. You forgot that?
I have no idea, Your Lordship,
Okay,
because
After some The
senior
person-
counsel is stuck in
it's on
heavy
the
traffic
way.
congestion.
Okay,
Therefore, matter may be passed over for a moment.
after some time.
Matter is endorsed to our learned VP. He is now RBC, engaged in RBC with the video calling. So video conferencing. So I will take it up.
Okay, what remains otherwise?
Settlement.
My Lord?
Hmm?
Settlement, my Lord.
Yes, what do you want? You are going to take up the matter?
Yes,
Okay,
interesting.
so now the case of wife and husband.
Yes.
What is the offense involved?
It's, Your Honor, my Lord, 498A, 509, and 323.
I think that can be compounded.
Yes.
I'll pass order then.
Matrimonial issue.
Hmm?
Matrimonial issue. It can be placed.
Yes,
Matrimonial issue. It can be.
yes,
placed.
that is right. Just a minute. Huh? Yeah, when the agreement entered between the parties? March 8. Okay,
Page 60.
Hmm.
Page 60.
yes, yes. Who appeared otherwise here? PP, who was PP here? For the state, who appeared earlier?
D. Loy, T. Sorry. T. is absent today, and D. Loy was re-endorsed. Now he was called for RBC.
Hmm?
RBC video conferencing with Kardak, Justice Kardak.
Heard Mr. G. Tadi, learned counsel for the petitioner. I've also heard Mr. G. Tado. Counsel appearing, then additional PP for the state. No? Okay, just- Just the material. Huh? Practical case. This is an application. The joint application.
Yes, my Lord.
This is a joint application filed by the petitioner seeking passing of the GR case number 649/2023 arising out of Kitab WPS number 79/2023 under section 498A stroke 509 stroke 323 IPC. Stop. The petitioner number 1 is the petitioner number 1 complainant is the wife. The informant is the wife. And the petitioner number 2.
Your Lordship, her name may be reflected
Okay.
because there.
So,
petitioner
Is there This is a matrimonial case. You have any objection? They have entered agreement.
Matrimonial issues, they're
Ma-
still living as husband and wife, they're
Okay.
one,
Husband and wife having 2 children.
yes, your
Now,
lordship.
no problem. Domestic violence case.
Yes, even the charges under 323 is also simple, your lordship. There's no objection to that.
Okay. The petitioner number 2 accused is the husband. So, okay. So I'll pass order. Okay. Then, her name, huh? Eugenie. Instead of that, huh? Eugenie. Okay. Dispose. Chamber, okay.
Your lordship, if I may interfere, lordship, item number 2, since myself as well as the counsel for the petitioner were struck in the traffic, your lordship.
Item,
2,
okay, 2
This-
not yet taken,
yes,
not yet
Pass.
taken, pass up for the time being only.
yes.
Hmm. Who is for the 8th? Yes. Item 8,
May I please your lordship?
yes.
Lordship, I am appearing for the applicant, my lord.
Hmm.
In this case, lordship, earlier we are granted pre-arrest interim bail, lordship. And pursuant to the order dated 29/4, my lord, we have appeared before the IO. But
Hmm.
what happened, lordship? IO did not record my statement. Instead of that, lordship, IO was putting pressure on me to pay the whole entire amount which is allegedly due as per the FIR, my lord, along with interest. And he was also asked me to confront the informant, my lord, and therefore he asked me to stay 2 more days, since on that day the informant was not available in town, my lord. My lord, in that regard, lordship,
When did you appear before the IO?
I have appeared before the IO on 7th of May, my lord. I have filed an additional affidavit in connection with that, lordship. Regarding my appearance, I have filed an additional affidavit that your lordship will find in record, lordship. I have also annexed the photographs taken in front of the police station. I have annexed the travel tickets. I have also annexed the temporary inner line permit which was issued to me, my lord. All the documents I have already annexed with the additional affidavit.
Your additional affidavit is not on record.
That I have,
It hasn't come yet.
lordship, I have filed on.
This is regarding what? Additional
This is
affidavit for what?
this is regarding my appearance, my lord.
Okay, so there is a document also you have.
Yes, I have annexed the documents.
Okay. Let your additional affidavit be listed along with the this AB.
My lord,
Okay.
my lord. Then some time may be granted, my lord. A date may be
Oh,
fixed
oh.
in that case, lordship.
You are Mr. P. Deka,
Zaman, lordship.
MM.
Zaman.
Mr. MM Tamam, now counsel for the petitioner, who submits that he has filed, who submits that after obtaining the interim anticipatory bail on 29/4/2025, the accused applicant appeared before the IO of the case on 7/5/2025. Thereafter, he has filed an additional affidavit, which is not on record. So let the additional affidavit be placed along with the AB next week. So, Ms. Eugenie Lanin, additional PP for the state is also present. List this matter next week. Okay.
Can it be on 12th of June, my lord?
the interim order passed earlier. Till then, the interim order passed earlier. Then continue. Okay.
Your Lordship, also a direction for the updated CD, Your Lordship.
CD, you have brought the CD.
Yes, Your
Whether he appeared, you have the record.
No, in fact, there is a non-billable warrant issued by, it was issued earlier.
Okay, but since he has already filed
Yes,
additional, let it come. Okay.
I am already on interim, my lord.
yes, in that case, updated copy, because the allegation is being made and such.
Okay. Ms. Sancho, appear on behalf of, present on behalf of the state with the case study. Let the case study, case study be returned to be produced on the next date, to be produced on the next date.
Updated, yeah.
To be produced, updated CD on the next date. Okay.
On 12th of June, can it be, my lord?
12, is it okay?
Yes, Your Lordship.
Okay, then the last, as requested, let the matter be listed on 12, on which date who produced the CD? It's
IO, Your Lordship,
okay.
investigation
The
officer.
IO shall produce the updated CD. Okay.
I'm highly obliged, lordship.
Your Lordship, we are the petitioner in this matter, Your Lordship. If Your Lordship, kindly,
There you go. Service is not completed. In respect of R1 and R4, written answer. In respect of R2, it is already served. And in respect of R3 and R5, service
Is filed by the state. IA is for condonation.
Yes.
Okay. So respondent not yet appeared. The office note dated 19/5/2025 reflect that the notice upon the respondent number 1 and 4 no. Refer to the office. Okay, 3 and 4 are still awaited. So what about 1, 2, 1, 2, no, 3 and 5, huh? 1, 2, 4 has already served.
No, 2 already served, 1 and 4, written unserved.
Okay, the office note dated 19/5/2025 reflect that the notice upon the respondent number 1 and 4 return unserved. And upon respondent number 3 and 5 is still awaited. Stop. In view of the, what do we do with 1 and 4 then? You have to take fresh steps.
First step.
In view of the above, landed additional PP, Mr. G. Tata. Praise for allowing him to take fresh steps upon the respondent number 1 and 4. Prayer allowed. Steps upon the respondent number 1 and 4 by a registered post which vary through jurisdictional police station.
Yes. It is appeal prepared by state.
Okay, then who will take steps? Who take steps on behalf of the state?
PP office will take step through jurisdictional police stations.
Okay, they'll take steps upon the respondent number 1 and 4 through the jurisdictional police station. Within 2 weeks.
1 week.
Within a week from today. Okay. List this matter after 2 weeks. Where the address of the, is it far away? Is it the address of the respondent? Near or it's far away? Or,
4 weeks, after 4 weeks.
after 4 weeks.
Yes, notice has to be served and
Okay.
a report
Yeah,
has to be
This
received.
is matter after 4 weeks. Okay.
Mobilizer.
Yes.
Your Lordship, on the earlier occasion, fresh step was to be taken upon respondent number 2 by the petitioner.
Not yet taken.
Your Lordship, since the council is also not present, if your Lordship pass over this matter, or
Council otherwise is likely to appear today.
since there is heavy traffic, your Lordship, I'm,
Okay. Then let him take steps.
yes, your Lordship.
The office note dated 19/5/2025 reflect that the petitioner has not taken fresh steps upon the respondent number 2. No, the petitioner is yet to take steps upon the respondent number, take fresh steps upon the respondent number 2. Stop. The petitioner is granted further 1 week time to take fresh steps upon the respondent number 2. By a registered post with AD within a week from today. Yeah. What is it? List this matter. After 3 weeks. Okay. Yes.
I'm sorry for interruption, my lord. My lord, in item 8, actually, there is an anticipatory bail, my lord. It's already gone, your lordship. Here, your lordship, we have received the updated status report.
So the petitioner has filed
IA,
IA.
yes, to bring into the record that
Additional affidavit. Probably he appeared after obtaining anticipated bail. He appeared before.
that is not disputed, my lord.
Huh.
He admitted, but his statement was not recorded, giving him the next date to appear before the court,
Yes.
before the concerned IO.
What do you want there? But he appeared through.
And initially he appeared, but his 161 statement was not recorded so as to cross verify his statement, because he has stated that some certain amount has been paid. So
What he was submitting
Yes,
is
Your
that the police is compelling him or asking him to pay all the amount along with the interest, etc.
no, my lord.
Anyway, since he has filed and when he was appearing through video conference.
Okay, no, my lord, just to record that on the next day the status report,
Yes.
yeah, updated.
Updated.
Yes,
sir. That is.
yes, yes, Your lordship. Obliging.
Eleven lists after 3 weeks. Huh? Is it? Okay. This is where is the main case? Has filed Wakalat Nama. Let us. Okay. None appears. Just a minute. The office note dated 17/3/2025 reflect that the respondent are represented by the advocate by filing wakalatnama. However, no one appears on behalf of the respondent. In view of the above, the matter is adjourned. List this matter after 2 weeks. The registry shall reflect the name of Sri A.K. Singh, N. Kakum, and P. Nima as the counsel for the respondent. As the line of counsel for the respondents. Okay. List this matter after 3 weeks. After 2 weeks, did I say 2 weeks? Okay.
Your Lordship, service is still awaited.
Service still awaited.
Yes.
Unserved notice was received. And TCR is also not received, Your Lordship.
TCR also still awaited.
Yes, Your Lordship. And the notice was not served.
From which court?
Capareda, Your Lordship.
You are Miss?
A. Rai.
Hmm?
A. Rai.
A. Rai, land counsel for the petitioner. Is present?
Yes.
So, So are they, the respondent did not appear in the,
Your Lordship will kindly peruse, Your Lordship, the last order 23/1/2025, Your Lordship.
military?
1/2025 by this honorable court. Your Lordship.
Yes.
Wherein, Your Lordship, in serial number of number 4 para, the petitioner are directed to take press step for issuance of notice to the respondent number 2 by registered court with AD within 4 days from the date of this order, returnable after 3 weeks. So after this, whether they are taking steps.
No, there is a.
We have
this
taken
note,
steps.
Then service report in respect of respondent number 2 has been received from OCPS, the provision. Listen.
It's unserved notice, my lord. Your Lordship will find
It's
in.
unserved.
Yes, unserved. Your Lordship will find in the
Then
flag.
probably you may have to take press steps.
Yes, absolutely, Your Lordship.
You did press steps. Okay. Return the service notice. It appears that this was served. So, return the copy of the service notice. Remarks says served.
My lord, kindly allow me to go through it. Your Lordship, here service copies, witness. Here is the, Your Lordship, the main part. Officer insert signature, Your Lordship, the victim, the respondent number name is Omam Gade. But your lordship, it was served to somebody as brother. It will not suffice.
No.
It's written, your lordship,
You
relation
take great
brother.
steps, okay?
Your lordship will find remark on the margin, my lord. Down. It's received by the brother. There, yeah, down, bottom, my lord. Written by hand, my lord. Omar Gade.
Relation,
Yes.
younger brother, no.
It has to be served to the victim itself.
Hmm.
Your lordship, let them direct to take press step through the concerned police station. And your lordship, it may be clarified that it should be served to the respondent itself, not the relative.
Miss Rai, or Miss Rai, Lana counsel for the petitioner starts. The office note details. 19/5/2025 reflect that. No, 10/3/2025 reflect that the notice upon the respondent number 2 was served. However, the record however, the return notice reflect that it was served to the younger brother of the victim and not to the victim. In view of the above, the petitioner prays for allowing her to take fresh steps upon the respondent. Stop. The prayer is allowed. Fresh steps upon the respondent number 2 by a registered post with AD
Yes.
as well as
Through
Usual-
jurisdictional police station.
usual process through the jurisdictional police station within a week from today. Stop.
And my lord, it may be further.
Which
Yes.
The notice shall be the jurisdictional police station shall ensure that the notice is served upon the victim or not the victim, to the respondent to in person
Yes, your lordship.
and not through any other person.
Your
This is-
Lordship, there is interim that may be continued.
This is matter after
3 weeks, your lordship.
3 weeks.
3 weeks. Stop. Mr. Ete, Mr. T. Ete, Lana additional people is also present. Stop. Thereafter, only list is matter after 3 weeks. Till then, the interim order pass earlier shall continue.
And my lord, one more thing, your lordship, perhaps TCR has not been received.
Okay.
So reminder to the registry.
The record further reveals that the trial court record, sorry, the office note further reflect that the trial court record is still awaited. Stop. The registry shall issue reminder for the trial court record.
Yes, it is. Deeply obliged.
Your Lordship, in this matter, step is already taken through usual process and AD.
Awaited. The okay, Ms. Rai, Land Counsel for the petitioner is present. The service upon the respondent number 1, respondents are still awaited. In view of the above, let this matter be looked at after 3 weeks.
3 weeks.
Okay. The
Your Lordship, there is an interim. Interim may be continued.
this is matter after 3 weeks. No? Okay, till then, the interim order pass earlier shall continue. And the interim order pass earlier shall continue till the next date of listing. Okay.
Deeply obliged.
Service report awaited.
Hmm?
Respect of R2.
Lordship, interim prayer in this case was, interim prayer in the case was supposed to be considered today.
Today,
But Your Honor, since the conducting council is out of station, it may be fixed on Monday, Your Lordship.
you are Miss,
The river,
the Revenue Council, submits that the conducting council is out of station, therefore pray for listing this matter next Monday.
yes, Lordship.
The prayer is allowed. List this matter. Next Monday is age requested, let this matter be listed on 26. Okay. 26. Okay.
Deeply obliged.
Mr. G. Taro, additional PP is present. Okay.
Deeply obliged.
One more matter, item.
Your Lordship, I am seeking for adjournment. Community council for this matter is not affair to this.
Item 17.
Yes, Your Lordship.
Okay. Mr. You are Mr.
Sita Jo.
Submits that the conducting council, Mr. D. Pangan, is out of station, therefore pray for adjournment of the matter. So, no one appears on behalf of the respondent. In view of the above, the prayer is allowed. Let the matter be listed. When do, after 3 weeks?
2 weeks.
After 2 weeks, okay.
Overless.
Yes,
But this matter, either for the petitioner or for the respondent, has become infrastructure per se, Milord. Milord, what will happen is, now after coming into force of the Civil Code Act, which has given the retrospective effect, then any decision, appeal against the decision of the village authority will lie before the judicial civil judge junior division. They similarly, now they have filed a restitution application, Milord, under section 9, read with 151 of the CPC. Now, normally we file divorce suit under section 21 of the CPC as a divorce suit. Now what has happened is, civil under CPC, the regular civil judge are not empowered to adjudicate the marriage, dissolve the marriage, and until or unless if it is to be, it is by the family courts. So we are yet to notify the family court. So therefore, Milord, since 35 years ago, now the matter is of 2016. Yes. 18. 18 means another, Milord, 7 years gone. So that means 43 years now. So no purpose will be served, Milord. Can we close this close this civil revision petition with an observation that in view of the amendment, the introduction of the Civil Code Act, which has given the retrospective effect, amending the AFR 1947, appeal against the village authority will lie because our appeal is pending before the ADC. Now that forum is no more there.
okay. So that your appeal is still pending before the ADC. Actually, ADC should have been transferred then.
It's gone, Milord. There's no purpose.
No purpose.
No purpose. Similarly, they also have filed the
now what the direction should be then?
Direction should be, Milord, both the orders should be both the proceedings in the AD before the ADC and the district judge Pasigar should be interfered with, giving liberty to both the parties to approach appropriate forum.
Is it okay for you?
That's
Okay.
I took, Milord, 1 hour 40 minutes to reach.
Yes, today suddenly it has changed. I've seen. I don't know why.
No, Milord, what will happen is that bridge, Logan Bridge
Started.
has been blocked.
Okay.
And now it has become bottleneck Naharlagan means gone case, my lord. There's only one point coming to Itanagar, then that Borum and all. So I think this executing people, agencies, they were sleeping for long, did not do anything.
Now
and
started in the
suddenly-
rainy days.
Rainy days and harassing the citizens.
Okay.
My lord, you pass that order.
This civil revision petition. Then, sorry, this application under Article 227 of the Constitution of India was filed with a prayer. What was your prayer here?
Prayer just for Google, just I assist you know, civil-
Against the Kebati? Oh, okay, file against,
My lord, page 20.
against the institutional file, I feel like. This is,
PSC restitution case number 01/2017.
was in setting aside, with a prayer for setting aside. Passigat restitution case number 01/2017. Instituted, just in 2027. Pending disposed before the court of their deputy commissioner, Passigat. Under AFR 1945. And to dispose of the appeal dated and for appropriate order directing the deputy commissioner to dispose of the appeal dated 10/4/2015 and 19/11/2015. Expeditiously. Two prayer, I think.
Correct. Two prayers.
Okay, start.
To be marked.
Start, huh? However, at this stage, Mr. Tara, T.T. Tara, land counsel for the petitioner, submits that after, since this was filed, okay, the civil code, since now the Civil Code Act 2021 is made applicable
With retrospective effect.
with retrospective effect. Huh?
Correct.
And then under the Civil Code Act, who is the author?
Junior division.
And under this act, the
Section 20.
civil judge junior division is the appellate authority, appellate court for the
15.
Keba, customary court, and the district judge is
And
the
Appellate authority.
appellate authority for the civil judge.
Yes. Civil judge, junior division.
Civil judge junior division. And now the case is pending before whom?
Now the case is before the additional district and session judge Pasika, that restitution case. No, my case,
Okay.
ADC Ruksit,
Okay.
ADC Ruksit. My appeal against the village authority decision is pending before the ADC Ruksit.
And in view of the above, the no useful purpose will serve. Okay? Therefore, praise for dispose of this matter with the direction to whom you said?
No direction would be
No,
required.
okay.
Because secondly,
With the
second-
observation.
my lord has recorded the first portion of my submission. The second portion is the restitution or the matrimonial divorce suit.
Restitution is pending before the
District session
district session judge.
Yes.
Filed by?
filed by them.
Okay,
as
filed
well.
by them, okay.
So what I mean to submit is, my lord, in terms of, they have invoked section 9, read with section 151 of the CPC to file that restitution suit. Secondly, now every time we have a practice here in Arunachal by invoking section 21, we files divorce suit title suit divorce.
Okay.
Now the law is well settled that regular civil court do not have the power to grant divorce unless that particular district is not notified, district court is not notified as a family court. So Arunachal so far has not done the notifications. So therefore, recently also my elder brother, Pratham is also there. He is also experienced the same thing. The larger district and session judge is returning the plate.
Okay. Okay.
So therefore, that both the proceedings be quashed and set aside, and give liberty to both the parties to approach appropriate forum.
Mr. You have, so this will be disposed of.
Yes.
Giving liberty to both the party to approach the appropriate forum.
Yes.
Is it okay?
Yes.
Okay.
But my lord, quashing and setting aside, my lord, I don't. We can.
No, that because under CPC.
No, that part, my lord, definitely the parties can approach a trial court, my lord, and place the facts that it has, my lord, regarding jurisdiction and all that, my lord. That can be raised before the trial court, my lord. If a stamp of this Honorable High Court is given, my lord, it would be difficult for the parties to agitate before the lower court, my lord. So let the matter be closed, but directing the parties to approach the appropriate forum.
That's
for
fine.
that would be to best of interest to all the parties, my lord. There will be nothing more, my lord. No impediment as such to us, my lord. Both of us.
Okay, heard Mr. Tiditara, also heard Mr. Tiditara, Learning Council for the petition, and also heard Mr. Tapo, Learning Council appearing on behalf of the respondent. So in view of the submission made above, both these civil revision petition stands closed with the liberty to both the party to approach the appropriate forum. Okay.
Yes.
Approach the appropriate forum for appropriate relief.
Yes. Much.
I have the meeting.
Yes, please stand.
I am Is there anyone online? But to be very fair side, I have not laid my hands on this.
Okay.
I saw her name also. When?
Your lordship, if your lordship picks this matter on first week of June, your lordship,
Fine.
First week of June.
20 June.
Entry model.
20
Okay,
June.
both the Learning Council for the parties are present on the request of both the parties. Let this matter be listed during first week of June.
First week.
You want particular date? No.
Particular
5 June.
5 of June.
Okay. On 5 June. Okay.
Entry
The following principle may be stated in relation to the exercise of the inherent power of the High Court. That in this guideline, the first point is what I'm relying upon, Your Lordship, that the power is not to be resorted to if there is a specific provision in the court for redress of the grievance of the aggrieved party, Your Lordship. Now, Madhu Lamia, Your Lordship, while dealing with compounding of offences, Your Lordship, has also dealt under 482 the unlimited power of the unlimited inherent power of the High Court, and where can it be invoked, Your Lordship. Madhu Lamia clearly states that it cannot be invoked if there is a specific provision in the court for the redressal of the grievance of the aggrieved party, Your Lordship. Now, Your Lordship, then come to paragraph 8, Your Lordship. In State versus Navjot Sindhu, so after a review of large number of earlier decisions, it was held as under. The inherent power is to be used only in cases where there is an abuse of the process of the court or where interference is absolutely necessary for securing the ends of the justice. The inherent power must be exercised very sparingly, as cases which requires interference would be few and far between. The most common cases when inherent jurisdiction is generally exercised is where the criminal proceedings are to be quashed because they are initiated illegally, vexatiously, or without jurisdiction. Most of the cases set out herein above fall in this category. It must be remembered that the inherent power is to be resorted to if there is a specific provision in the code or any enactment for redress of the grievance of the aggrieved party. This power should not be exercised against an express bar of law engrafted in any other provision of the criminal procedure. This power cannot be exercised against an express bar in some other enactment. Paragraph 9, Your Lordship. In Arun Shankar Shukla versus State of UP, the High Court had entertained a petition under Section 482 after an order of conviction has been passed by the session judge and before the sentence has been awarded and further proceeding in the case has been stayed. In appeal, this court set aside the order of the High Court after reiterating the principle that it is a well settled that inherent power is to be invoked in respect of any matter covered by a specific provision of the code or if its exercise would infringe any specific provision of code. It was further observed that the High Court overlooked the procedure law which empowers the convicted accused to prefer statutory appeal against conviction of the offense and intervene and then uncalled for stage and often peddle the course of justice at a very crucial stage of the trial. The order of the High Court was accordingly set aside on the ground that a petition under Section 482 CRPC could not have been entertained as the accused has an alternative remedy of an appeal as provided in the court. It is not necessary to burden this judgment with the decision of this court, as the consistent view throughout has been that petition under Section 482 CRPC cannot be entertained if there is any specific provision in the Code of Criminal Procedure for redress of the grievance of the aggrieved party. So basically what the apex court on several, even paragraph 13, Your Lordship, where a reminder has been put, Your Lordship. If I may read, Your Lordship. Before parting with the case, we'll feel constrained to observe that in spite of repeated pronouncement of this code, that inherent power under Section 482 CRPC should be exercised sparingly with circumspection in rare cases, and that too when miscarriage of justice is done. The High Court entertained the petition under Section 482 CRPC. The ultimate result whereof was that the order of bail granted in favor of the accused for an offense under so-and-so IPC inured to their benefit even after the offense has been converted into one under Section so-and-so. Now, basically, Your Lordship, the apex court has clearly said that the unfettered, unlimited power of the High Court can be exercised when there is vexatious litigation illegality, Your Lordship. However, the statutory provision provided under the code, Your Lordship, if there is one, the party cannot leave that statutory provision and approach the court under 482, Your Lordship.
What according to you is the statutory provision in the present case?
Revision, Your Lordship. Revision, Your Lordship. Now, revision, if Your Lordship will pick up the revision provision, Your Lordship. 397 was the old Your Lordship. This is 438 in BNSS, Your Lordship.
4,
38.
397.
Yes, Your Lordship.
Okay.
Plot 38, Your Lordship. If I may read, Your Lordship.
Just
Calling
one-
for
just- Yes.
Yes, Your Lordship. Calling for records to exercise power of revision. The High Court or any sessions judge may call for and examine the record of any proceeding before any inferior criminal court situate within its or his local jurisdiction for the purpose of satisfying itself or himself as to correctness, legality, or priority of any finding, sentence, or order recorded or passed as to the regulatory of any proceeding in such inferior court, and may, when calling for such record, direct that execution of any sentence or order be suspended, and if the accused is in confinement, that he be released on his own bond or bail. So this is also a provision where Your Lordship can call upon the records of the trial court and interfere with the orders if they.
Yes. Are you, sure, please. Just a minute. Yes, so what do you want to show by this? 397?
397 is a power of revision, Your Lordship. The appellant had the statutory provision provided for challenging of an order.
How it is statutory provision?
Because this is in the statute. Civil code is all the provision under the code is a statutory provision, Your Lordship. Now, in this matter, Your Lordship, if any of the order of the court is challenged, Your Lordship, the High Court or any Sessions Court may call for examine the record of any proceeding before any inferior. So it gives power to interfere with the orders of any court inferior to the High Court, Your Lordship, as well as to the Sessions Court, Your Lordship. If I may, Your Lordship.
Hmm.
Chapter 32 of the BNS speaks
No,
about
see,
reference and
this is
revision.
Not the question of any jurisdiction error.
Now, Your Lordship will then come to 442, Your Lordship. High Court's power of revision, Your Lordship. 442, Your Lordship. Four 38 is a general revisional power, Your Lordship. 442 specifically gives the power of revision to the High Court.
Four 42 of the BNSS.
BNSS, Your Lordship.
Please,
In case of any proceeding,
just a minute. Four 42.
yes, Your Lordship.
Yes.
In the case of any proceeding, the record of which has been called for by itself or which otherwise comes to its knowledge, the High Court may in its discretion exercise any of the power conferred on a court of appeal by section 427, 430, 431, 432, or on a court of session by section 344. And when the judges composing the court of revision are equally divided in opinion, the case shall be disposed of in the manner provided by section 433. Now, subsection 5, Your Lordship will see. Where under this Sanhita, an appeal lies, but an application for revision has been made to the High Court by any person, and the High Court is satisfied that such application was made under erroneous belief that no appeal lies thereto, and that is this necessary in the interest of justice. So to do, the High Court may treat the application for revision as a petition for appeal. Now, the only bar given in the power of revision before the High Court is that if there is a provision of appeal, then revision won't lie, Your Lordship. However, in this case, Your Lordship, there is no provision of appeal in second appeal, Your Lordship.
So according to you, there is a statutory provision for revision.
Revision, Your Lordship.
You
Now,
have
any,
any-
now, if I may.
Yes.
Just complete for a second. Now, as I have shown, Your Lordship, 438 is the power of the revision of the High Court as well as of the Sessions Court, Your Lord. Since in this case, the Sessions Court is an appellant court and the Sessions Court has filed the order, the impugn order in an appeal, Your Lordship, the petitioner approaching before High Court, the High Court shall have a revisional power upon the order of appeal of the Sessions Court. Now, the only bar, if Your Lordship will again come to 438, Your Lordship, the only bar is at subsection 2.
Subsection 2 of
2 of 438 BNSS, Your Lordship.
calling for record.
No, Your Lordship. Next page is the subsection 2, Your Lordship.
Hmm.
The power of revision conferred by subsection 1 shall not be exercised in relation to any interlocutory order passed in any appeal, inquiry, trial, or other proceeding. So this is the only bar. Now the petitioner has to satisfy this court that the impugn order that is being challenged is an interlocutory order or not, Your Lordship.
That
If-
is not the intellectual order.
Yes. And if he satisfied that this is an interlocutory order, then even the revisional power goes and 482 can be invoked, Your Lordship. However, if this is a final order, Your Lordship, the statutory provision is a provision of the revision, Your Lordship. Now, if I may.
Yes.
Now, Your Lordship, if Your Lordship then come to the Negotiable Instrument Act, Your Lordship.
Negotiable instrument.
If I may take Your Lordship to section 147, Your Lordship.
Yes.
147 speaks of compounding of an offense under the NI Act, Your Lordship. Notwithstanding anything contained in the Code of Criminal Procedure, every offense punishable under this Act can be compoundable, Your Lordship. Now, 148 is the interim relief, Your Lordship, during the pendency of an appeal. If I may read, Your Lordship. Notwithstanding anything contained in the Code of Criminal Procedure, in an appeal by the drawer against the conviction under Section 138, the appellant court may order the appellate to deposit such sum which may be minimum of 20% of the fine or compensation awarded by the trial court, so and so provided. Now, any action or any order under 148 during the pendency of appeal for payment of 20% of the fine or compensation amount, Your Lordship.
Just a minute, I'm not studying anything. No. See, this talks about during the pendency of.
Yes, my contention therefore is that 140, any order pass under 147, compounding the offense. Compounding itself means finishing of the case with consent or not consent, that's a part of the merit, your lordship.
He can be directed to deposit.
Yes.
Initially.
What I'm trying to convey, your lordship, order under 147, compounding an offense, is final order. If there was an order of the appellant court under 148, that during the pendency of appeal, 20% has to be deposited and can be given to the aggrieved party, your lordship. This order could have been challenged under 482, your lordship, because the revisional power clearly states that interlocutory order cannot be dealt in the revision, your lordship. So my contention is that since this is a final order, your lordship, in final order, the statutory provision provided is of revision, your lordship, under the Code of Criminal Procedure, your lordship. Now, if he is satisfied that this order is an interlocutory order, then his petition under 482 will be maintainable, your lordship. So the main crux that has to be dealt with is if the impugn order of the appellant court is a final order or an interlocutory order. If it's a final order, revision lies, and if it's an interlocutory order, 482 lies, your lordship. As far as my research, your lordship.
No, 482. Even against the final order also.
No.
It's not against the.
No, because final order, therefore, what I'm trying to.
So according to you, this will be converted into revision.
Yes, it can be converted into revision otherwise. My contention is that your lordship will see that for interlocutory order, any criminal court pass an interlocutory order, there is no statutory provision provided under the CRPC, and therefore the inherent power is invoked. For example, your lordship, there is no concept of compounding, just a compounding of the offense under old codes 320 by the parties, but there is no concept of compounding of offense by settlement between the parties. It was only through the guidelines of the apex court when which has dealt with the settlement between the parties and can be compounded, your lordship.
And what you submit merit?
Merit, your lordship, will come. If I may take your lordship to the petition, your lordship.
Apparently there is.
Yes.
Then can it be converted into revision and then say remanded back to the trial court?
Your lordship can do that. However,
in any case, it has to be.
It has to be, your lordship. In any case, otherwise, I'll just rely on Raj Reddy Kellyam's case as well as this Meter and Instruments Private, which has already been referred to in the impugned judgment, your lordship.
What do you have the Damodar?
Damodar's case is also there. I'll just come to that.
Can you just see?
Yes, your lordship. I'll just, in that case, bring your lordship to page number 33 of the impugned order, your lordship. Page number 33, your lordship.
Yes.
Paragraph 11, your lordship.
Para
11, yes, Lord.
11 is. Yes.
In present case, the impugned order is in connection with check number so and so. However, there is a different other transaction between the parties, and there was previous record of compounding of the case amongst them. It is seen from the record that the case is so and so could not be compensated. So there was already a compound settlement between the parties in this particular manner, your lordship. In the case of Damodar, while
do you have the copy of the Damodar case?
I'll
Two 2010-5.
just me gives.
Damodar, it partners with the imposition of compensation. Compensation. How much compensation has to be imposed?
Yes.
why compounding of the principal? That was only the concern with the case.
The consent of the parties is required. The observation.
The yes, the Damodar case basically there was a guideline put.
Guideline, that is.
10%, 50% and 20%.
Complainant
Yes,
is required.
it's even in the barrack.
Can you
Your
just Damodar?
If I'll just rely on the barrack, Your Lordship, just the guideline part, Your Lordship.
Okay.
63.
You have.
Yes, at page number 53. What, enact. That's one.
Call from library.
I have Your Lordship, but then I have to go to.
Call from library. Books, for that book.
Basically, if Your Lordship wants to peruse the same, Your Lordship.
What it says.
The main issue here is with regard to quantum of compensation, Your Lordship, and also deals with 147, which is compounding of offense, and 320 under the CRPC. Since the 147 section 147 start with a non-obstante clause, therefore the apex court has stated that under NII compounding under 321 be taken into consideration, except since there is already a provision under 147 that has to be taken into
But in
consideration.
any case, it cannot be in absence of
Yes, but
complainant.
then I will come to Raj Reddy Kalam's case, Your Lordship. Raj Reddy Kalam's case, which is of 2024, Your Lordship.
Where is the guideline part is in the para.
Let's take a look.
Guidelines, okay. After there are 15.
Excuse
It's a deposition of the amount quantum.
me. Yes, yes.
So it's around 15. So
Same.
in the present case, what was the amount? 15%? 75. Or 75. Okay.
Fifteen 15%.
The present impugn order did not say anything about the fine imposed, ₹5 lakhs.
It speaks about it, Your Lordship, at paragraph 12, Your Lordship.
Okay,
If
what
I
it
made it.
what it says.
As the convict appellant in the present case is willing to compound the case by paying the check amount, it is ordered that as provided by the guidelines of the Honorable Supreme Court, and for compensating the complainant adequately, the convict appellant is directed to deposit an amount of ₹5 lakh with 15% compensation on the check amount and ₹25,000 as the cost of the litigation before the District Legal Service Authority.
No, this 5 lakhs of fine of 5 lakhs.
No, 5 lakhs, as well as 15% compensation of the 5 lakhs, as well as 25,000, Your Lordship.
The 5 lakhs is the amount.
Check amount.
check amount and 5 lakhs is fine amount.
That's what, Your Lordship. While compounding the offense, Your Lordship, the appellant court has taken into consideration that 5 lakh is the complaint amount. So while taking into the guideline provided, Your Lordship, it speaks about Damodar's case, Your Lordship. 15% of the complaint amount, the check bounced amount, Your Lordship. And therefore, the court has directed him to pay 15% of the 5 lakhs amount that has been bounced.
Not the 5 lakhs.
Not the 5 lakhs.
So that is why I'm
And also 25%. Now I'll just come to Raj. I'll just surprise Your Lordship with regard to the case of Raj Reddy Kalam's case, Your Lordship. I have also not taken
And in the appeal, during the pendency of the appeal, the applicant or the appellant can make an application for compounding of the case. And in the present case, on the first hearing, without making such application, it was disposed of.
That is not a part of that is the inherent that is the discretionary of the appellant court, Your Lordship. Be it on the initial stage of when the trial was conducting, Your Lordship, or the initial stage of when the appeal is being taken up, Your Lordship. There is no bar to that. That apart, Your Lordship, I'll just explain, Raj.
There is no bar, but then provided the party is present, complainant.
Yes, that ought to have been even my consideration that at least a notice ought to have been given.
Yes, yes.
Therefore, I'll just come to the 3 citation that has been covered by the appellant court, Your Lordship. Raj Reddy Kalam's case is that the parties were willing to compound. There was already a compounding agreement between the parties, Your Lordship. Now, and there was a direction by the Honorable Court to deposit certain amounts with a compensation, certain percentage of the compensation. Now, since the accused had delayed even after that order, the complainant did not wanted to compound anymore. And therefore, the willingness, since there was already a compounding agreement between the parties, the willingness of the parties were not taken into consideration while compounding the offense. Your Lordship will see that has been relied at page number 32 of the, this is a very recent judgment of 2024, 8 SSC 588, Your Lordship. Now, even in Meters and Instrument Private Limited, Your Lordship, why was the court of the impression that the consent was not necessary, Your Lordship? Even in this case, there was already an agreement of compounding had taken place between the parties. However, on the later stage, the party did not want to compound, and therefore, otherwise consent is mandatory, Your Lordship. There is no doubt on that. However, the facts and circumstances of each of the cases has to be dealt with accordingly.
So in any case, what we'll do at the moment is that the private respondent is also not before us.
Yes.
We can issue notice, and in the meantime, the impunity order will be stayed. Okay, and then keeping it open for the maintainability.
Oh, yes, Your Lordship.
And then in the time will come that this may be converted into revision.
Yes, Your Lordship.
Okay, so we'll not do in that, we'll do in presence of the
Since- yes.
respondent. Okay,
Hello, I have some authorities.
what is that?
This Malot absolutely clear. No? There cannot be a bar of.
Yeah, that is there. That is why we are staying, and then let the private respondent appear.
Can be, Mr. Today still.
No, in
No,
absence of,
again,
again,
again, there will be
again,
notice
that
has to
will
be
be
given.
repeating, without giving an opportunity to the private respondent. What is this authority about?
All of these are FX code. It's
Yes. Can you just pass? What is this about? Because while passing the impugn order, he has also referred some citation. So that is why.
If party to the
These can, of course, if provided the party is present, this can also be disposed of today
Yes,
by
yes,
remanding back.
yes,
remanding.
yes.
So I was also thinking that way, but then the private respondent need to be given an opportunity.
Also, since this was not at all an objection per se, but then at
Yes.
least apprising the court that
Right.
certain provision sections has to be dealt with accordingly.
Right.
will find this first citation, Malot.
According to the 482 lies.
Yes.
So I was also thinking that way, but then we'll keep it open for further discussion.
Yes.
Whether an application is.
This authority has Malot absolutely settled the law. There cannot be an embargo.
Yes. Which case is it?
Prabhu Chawla.
Yes. More
2016.
specifically, because this case also, Your Lordship will see that, as I has already pointed out, subsection 2 of the revision provision, Your Lordship, it's a bar upon taking a revision petition in interlocutory order, Your Lordship. But therefore, I was saying that if this is an interlocutory order, 482 is not barred. For the embargo put upon the revisional power for taking up an interlocutory order cannot in any way fetter 482, Your Lordship. Then 482 lies, but only therefore I was submitting that he has to convince the court that this is not an interlocutory order, Your Lordship.
What was the decision in these issues?
It was ultimately held that since alternative remedy of revision lies, therefore 482 cannot be dismissed.
Okay. So these, of course, only because a revision petition is maintainable, the same by itself, in our considered opinion, would not constitute a bar for entertaining an application under section 480.
Yes, if 397 is maintainable, Your Lordship. The issue there is completely different, Your Lordship, because the apex court on many cases has clearly stated that 397 2 of the embargo will not fetter 482, Your Lordship. Basically, that's the case.
It's for Malone is the Raj Reddy case. Raj Reddy case. This is a case, Malone, which went up to apex court. And Malone, ultimately, apex court, Malone, while invoking the article 142 of the Constitution of India, without the consent of the complainant, it has compounded the offense. So, Malone, since this appellate court below, he is not been conferred with article 142. In the absence of consent of the parties, he cannot. Therefore, the appellate court has misconstrued with the findings of the Raj Reddy case.
Okay. Mr. G. Ruba, Land Counsel for the petition, also had Ms. Jenny, Land eligibility for the state respondent. This is an application filed under section 528 of the BNSS 2023 for quasi and setting aside the impugned ex parte judgment and order dated 2/5/2025 passed by the Court of Session, passed by the Session Court, UPR, in Criminal Appeal number 05/2025. Issue notice. Record need to be called for?
Yes, Your Lordship.
Okay, call for the record. Start. Since Ms. Jenny appeared and accepted notice on behalf of the state respondent, no formal notice need be issued to the state respondent. Stop. However, the petitioner shall take steps upon the respondent number, private respondent by the register post with AD within a week from today. Stop. Having regards to the complaints raised, the impugn the operation of the impugn judgment. And order dated 18/4. There is, no,
No, 0205.
date of sentence.
Yeah.
Date of, huh?
0205.
Where do we find? 0205.
Yes.
No, this is JMFC order.
2nd May 2020.
Mhm. Yes, 02/05/2025 shall remain stayed till the next returnable date. Okay. The age raised come the question of maintainability is kept open.
Yes, sir.
Okay, least is matter after 3 weeks. Okay.
Deep reflection.
Okay. Okay, on press. Habis. Here on. Gap. Yes.
My lord,
Item 6. Okay.
My lord, consecutively for 7 time, the sole respondent has sought time for filing of counter affidavit, my lord.
Affidavit not yet filed.
No.
Who is for the respondent? You are for the petitioner.
Yes, ma'am.
Who is for the respondent?
Kamal Saxena, and there are batteries of lawyers, my lord, but they sought times consecutively over 7 times, my lord. So this can be decided. They have
So
the
they,
liver.
they are not appearing today.
No.
But otherwise, the advocate used to appear. They have been appearing, but not yet filed the affidavit in opposition.
Oh, my lord, in this, all the 7th appearance, they are seeking for time only for filing of counter affidavit. If the matter is even decided, my lord, they have the liberty to file for restoration, my lord.
Mr. Nalapal, Land Counsel for the petitioner. None appears on behalf of the respondent. Since when they have been taking time
Since
for
my lord,
filing
since
filing
my lord,
affidavit?
23/7/2020 from
23/7.
2027.
27. 23/7.
Yes, ma'am.
Okay.
After filing of wakalatnama.
So on which day they submitted that they want to file affidavit? No, no, on the 4/2/25 only one occasion. Okay, so the respondent has not yet filed affidavit in opposition. What is this matter about otherwise?
Lordship, I have challenged execution proceeding along with the impugn order passed in the execution proceeding, execution petition.
Execution against you,
Yes,
but it is stayed now,
yes, it is system.
then what? You are in the advantage position.
My lord,
Otherwise, the property in question is under your possession.
yes, my lord. I was directed, my lord, by the village authority to pay some fine, my lord. So which I challenged.
Fine, how much?
Fine of 50,000 only
For what?
for making some defamatory statement against the.
Okay. Okay, so you have challenged the execution.
Yes, my lord.
Execution court cannot do anything, can't change even a comma. So in any case, they are going to execute it. So you pay unless you challenge the main order itself.
My lord, that earlier decision passed by the village council is set aside by a affiliate forum, Bango Kebang.
Now, have you appealed? Have you filed appeal against the Kebang?
Yes.
Kebang order?
Yes, my lord.
Has it been listed along with this?
Yes, my lord. No, in the execution proceeding, it is not mentioned.
No. Are you challenging
Yes.
the order itself or Kebang order itself?
No execution proceeding.
The execution petition, what I'm saying is execution petition, they cannot change unless you challenge the main order. In the execution petition, it's a stay is temporary.
But my lord, the Kebang decision, my lord, on which they have filed execution proceeding, execution petition, that has been already set aside by appellate Kebang authority, the Bango Kebang. So instead of challenging the judgment passed by the Bango
Okay,
Kebang.
the execution is proceeding otherwise.
Yes, that is defective.
Okay, okay. Then no problem, it's not urgent.
Yes.
Because you are in an advantage position, and in any case, you have a good case, it appears. But then what we'll do, whether the record was called for?
Yes, ma'am.
Whether the records has arrived, have you received? Okay, the record has also, but the record, when, by which order the record was called for? Yes, yes, record has called for. The record has also not been received. The registry shall issue reminder for record. So, list is matter after 3 weeks.
Yes.
Okay.
My lord, the interim may be allowed to continue.
Stop. The interim order passed earlier shall continue till the next date of listing. Okay, now what we'll do? The interim order passed earlier shall continue till continue. No, okay, next date of listing. Okay.